Good morning, everyone, and welcome to our latest edition in Retirement Plan Academy, our series of webinars that began pretty close to the beginning of this pandemic, and unfortunately, we're still doing them, but that's sort of where we are today. So today, we're going to cover trends in retirement plan lawsuits, a topic that none of us ever want to be a part of, but it's also something we certainly need to be aware of. The purpose in this, before I get to introductions, in no way is this an attempt to scare or anything like that. We really have two qualified, outstanding ERISA attorneys who are here to help us prepare and understand what we can do to avoid these types of situations, or at least be ready for these types of situations. So with that, my name is Zach Hurst. I am with the Trust Company of Tennessee. We are a Knoxville-based financial planning firm with locations in Chattanooga and Tri-Cities. And we have several lines of business, if you will, but really focus a lot and very heavily on our 401k operation and being a provider of 401k plans and retirement plans, mostly across Tennessee. So with us today, we have Bill Robinson and Kathy Aislinger, two ERISA attorneys in the state of Tennessee. And Bill and Kathy, I'll get to you in just a minute. If you don't mind, I'm going to lay out some of the ground rules, for lack of a better term here, but I wanted to point out to the audience, on your panel, you're going to see one section that says questions, and the three of us very much encourage you to ask questions as we go. We might be able to work in some of those questions as we go based on the topics and based on the flow of this, but certainly we'll leave time for those at the end. Also, we are providing CE credit through both SHRM and HRCI on this. We will send you the codes for each of those following this presentation. And with that, Bill and Kathy, I think I am through with my spiel and ready to jump in if you are.
I'm ready.
And great. And just a quick intro of the two of you. Kathy Aislinger is with Kennerly Montgomery in Knoxville. Kathy spends, I think, Kathy, almost 100% of your time on ERISA law or just law dealing with retirement plans in general.
Yes.
And yeah, and Bill Robinson, Bill really in the same boat. Bill's down in Chattanooga. Bill has been an ERISA attorney for, Bill, I shouldn't say how many years, should I?
Oh, you can say it. I feel every year of it. It's been 40 years and I feel them all.
Gonna say we're working on 4 decades of experience here, but we're really excited to have the two of you here. I think we're going to learn a lot more about not only trends in this space, but probably more importantly, the roles that an ERISA attorney serves, and really what you do on a day-to-day basis, and how people like us as providers and the viewers as plan sponsors might utilize your services as needed. So what I'd like to do is start with just a general understanding of who you are and what you do. And I've got some bullets here that we can follow or not. They're just sort of placeholders as far as I'm concerned, but really want to understand what you do day to day or week by week, what types of companies might use you, and at what point do they use you? When you see bullet number 2, are you only involved in lawsuits? I'm fairly confident that answer is no, but really just want to get a general sense of the types of companies and at what point you're brought in. So Kathy, if you don't mind, I can kick it off with you.
Sure. So an ERISA attorney is essentially an attorney that provides advice regarding employee benefit plans. And employee benefit plans are subject to 2 different laws. The one you hear the most about is the Employee Retirement Income Security Act, which is ERISA. That's how we get our name. And also the parts of the Internal Revenue Code that govern qualified retirement plans and health and welfare benefit plans. There are multiple types of attorneys within the sphere of ERISA attorneys. So you may have some attorneys that would work with participants in a plan to try to make a claim for benefits, get benefits under the plan, or bring in action for breach of fiduciary duty, which is what we're going to be talking about today. Other attorneys work with businesses, employers, fiduciaries, pension boards, those that are charged with the administration of the employee benefit plans. And that's what I do, and I think that's what Bill does as well, and he can give you a little summary on that. I work with all kinds of employers. I work with small employers with just 2 or 3 employees, and I also work with very large employers that have tens of thousands of employees. So it really runs the gambit. And what I do for those companies also varies. In many cases, I'm only called when someone notices a problem. Maybe it's someone from the trust company who's working with the plan, another plan advisor, a CPA. Those individuals will identify an issue and they may call me in to help solve that issue, whether it's a situation where the plan is getting audited by the IRS or the Department of Labor, or perhaps it's an issue that we've caught before one of those government agencies have come in and we're trying to come up with a plan to voluntarily correct the issue. So it really depends. Some clients I work with regularly on a weekly, occasionally even daily basis, and some, I may only talk to a couple of times a year.
I think my practice is very similar to Kathy's. I would add one thing to what she said about who ERISA attorneys are and what they do. There's a class of ERISA attorneys who call themselves ERISA attorneys, but what they do and what Kathy and I do don't have much in common. And those are the attorneys who handle disability claims, and what they do is represent companies like Unum and other companies that provide disability insurance. And then when somebody files a claim for the disability insurance that the disability company wants to contest, they'll hire an attorney to do that. And those attorneys call themselves ERISA attorneys, but they really don't do the kinds of things. They usually are only involved in lawsuits, and they don't really do the kinds of things that Kathy and I do. In fact, the number of lawyers who do what Kathy and I do across the state of Tennessee is small. It's a handful. And so generally our practice will be across the state or across the Southeast because there just aren't very many of us. And so we try to develop relationships with institutions like the trust company and advisors because they are the ones who are going to see the problems on the front end. And it's generally only larger employers that will come directly to someone like Kathy or someone like me. There was a time, I was telling you all the other day, there was a time when I started practicing when if someone wanted to put a 401k plan in place, they would call me and I would say, come down to my office and we'll design the plan. Who's going to be eligible? What are the features going to be? Is it going to have loans, hardship distributions, all those sorts of things? Where do you bank? We'll call your trust department. They'll set up a trust account for you to invest the money through, and you'll go off like that. And so I was involved from the very beginning. Now that never happens. There are too many other entities, insurance companies, brokerage firms, financial institutions that can help employers set up their retirement plan, whether it's a 401k plan or some other type of plan. And where we get involved, if that occurs, is when generally we hope we get involved when they're setting up the plan, at least to review the adoption agreement or the plan document to make sure that it complies and to make sure that someone hasn't inadvertently left off a box they should have checked or checked two mutually exclusive boxes or something like that. So we hope that an employer will allow us to look at the plan document before it's signed. But even after that, we get involved in the situation when there's a problem, which occurs fairly regularly. I've said a million times there are two types of 401k plans out there. There are those that have problems that are being fixed and those that have problems that nobody's caught yet that'll need to be fixed sooner or later. I also have some more specialized practice. I represent governmental entities with their defined benefit plans, small cities around the state, and other governmental entities that provide defined benefit plans, and they have their own set of problems. And I also advise clients who have union employees, and the union employees participate in union pension plans, multi-employer plans, and they have their own sets of issues. And so there's a broad range of things that we do. Yeah. Kathy mentioned briefly welfare benefit plans. We get involved in those questions as well. So
that's good. I've got a question actually on what you just said, and I like that, the two types of plans, those that have identified problems and those that don't know they're there yet. And so people who come to you on the proactive side and haven't identified problems, and maybe they don't exist, but those that seem to be okay so far, what is it that you really focus on with them? Like, what are the 2 or 3 things that you say, this is where most plans find themselves getting in trouble?
What I would say, Kathy, if you don't mind me jumping in, what I would say is what we're going to talk about in more detail, we might as well start now, is fiduciary duty. If you're an employer and you administer or maintain a 401k plan, for example, you have a fiduciary duty to administer that plan for the exclusive benefit of the participants and to make prudent decisions. And the standard, which is found in ERISA, is the standard of a prudent expert, not just a prudent person. It's a prudent person who understands what employee benefit plans are, what happens with a 401k plan. So you have it's the highest standard in the law. So the thing that I would advise clients, just the general thing I would advise them to do, is make sure that they have a process that they use to administer the plan, that they probably ought to have a committee of some kind that oversees the administration of the plan, and that committee ought to meet on a regular basis, and that committee ought to take advantage of the advisors, professional advisors that are available to them. But one thing I can say is that if you're going to have professional advisors, and every 401k plan needs professional advisors, you don't just sit back if you're the employer and let the professional advisors tell you everything that you need to do. You need to question what they're telling you, make sure you understand what they've suggested that you do or not do, and document the decisions you make so that later on, if there is a problem, you can show that you had a process in place and you followed it. Does that sound,
Yeah.
Kathy?
It makes sense.
Yes,
Yeah,
absolutely.
Kathy,
Absolutely. You know, and I would just add to that, in addition to making sure that an employer understands their fiduciary duties, particularly if you're putting in a new plan, or maybe if you're just amending and restating the plan, I always think it's a good idea to sit down and actually turn the pages of the plan document and talk about what the plan document says. Because sometimes employers think their plan is supposed to operate one way when what the plan actually says is something completely different. So if we will take the time to go through the pages, go through that long adoption agreement, talk about the definition of compensation and what it means and what's included, talk about having, informing eligible employees when they're eligible, getting them signed up, getting the deferrals quickly into the trust and not delaying that deposit. All of those things can really help head off problems that will arise.
I can give you a pretty good example. I think you're absolutely right, Kathy. That's very good advice. An example I can give you is a client that I have that was audited by the IRS. And one of the problems that the IRS picked up on was the fact that this plan was designed so that participants began to participate 90 days after they were employed. And the reason it was designed that way is because the employer had a 90-day grace, I guess, grace period, or a 90-day period. Yeah, that they would decide whether they wanted to keep the employee. So they allowed them to be employed for 90 days, and then at the end of 90 days, they became full-time employees, and they began to participate in the plan. Well, the problem was, at the end of 90 days, some of these employees, they hadn't decided whether they wanted to continue to allow them to be employed, so they extended that grace period for, maybe another 30 days or 60 days. But they didn't let them in the plan because they still considered them to be grace period employees. But the plan said at the end of 90 days, you begin to participate. So they had several employees who had been there longer than 90 days, but hadn't been allowed to participate in the plan. And the IRS picked up on that, and they got dinged for that. So yes, exactly what Kathy said is true. Those types of things are very important, even though they seem like they're minor things.
Yeah, and it's good to hear an example with that because it's something where some of these things just over the years, right? You just sort of maybe you get comfortable or you forget what's in that 90, 100 page adoption agreement, whatever it is. And you're right, whether it's ERISA attorneys or providers, somebody needs to really stay on top of all of that. With that, I think that we will have our audience help us out with a little poll question. And I think that's going to fire up in just 1 second. Here we go. Let me pop mine out so I can actually read this a little bit better. So the question is, when I read headlines about 401k or 403b plan lawsuits, I either get nervous because our plan might be next, am bothered, but I have more pressing things to worry about, or don't worry because there are not that many lawsuits. So Bill and Kathy, let's give everybody just a minute, see how the results come in. I'm guessing I don't worry because there are not that many lawsuits will not be the winner, but we'll see. Okay, just 1 more second. There we go. Am bothered, but I have more pressing things to worry about. I get it, right? These plan sponsors are professionals who have more responsibilities across a company than probably any other employee, and they're dealing with so many things. And this is but a fraction of what they do. And that goes back to, I think, the point that the two of you made previously, which is that's okay, but make sure you have the right people in place who you know and you trust and are presenting to you plan documents, right? Summaries of them, whatever it might be, to where you're staying on top of this. So that's interesting. So this slide starts with, you mean I can be sued? Yes, unfortunately, all of us, anybody who's tied in, as Bill mentioned earlier, as a fiduciary on a plan, be it a provider like us or a plan sponsor like many of you on this call, certainly can be sued. And you see, I'm not going to go through each of these cases by any means, but all of these are really, I believe, from about August on in 2020, and the trends in these lawsuits are going up substantially, and that has been something we've seen over the last decade, but this year alone, more and more. And Kathy, maybe I'll start with you on this. We're in a time right now where we've been in a pandemic for however many months. We hit a bear market back in March, quick rebound. We've got a lot of emotion riding around an election next week and what's going to come of that as it relates to markets. Does that factor into this uptick?
I think it might. As we'll really get into the details here in a few minutes, a lot of these lawsuits are really focused on fees. How much a plan is paying in fees, how much is passed on to the participant, and I think all of these things go into is a participant going to have enough money to retire? And there are so many factors that go into it. It's, are they saving enough? Is there a high enough employer contribution? And how much of their account balance is being eaten away with the fees that are charged? So I think it's just one more factor on top of an already very stressful situation as people try to plan for their retirements and employers try to help them have money to retire. It's one more stressor, one more factor that yes, I think it certainly can contribute.
Yeah, I would agree with that. Ironically, I think that to some extent, it may be triggered by the fact that there is now more transparency regarding fees than there used to be. I think there was a time when people just didn't understand what fees were being charged and they had no idea. In fact, I've talked to employers that say, you mean my employees pay for their retirement plan? They have to pay something for it? No, that's not right. Well, yes, there's a cost to every retirement plan. But for so long, those fees were hidden to the extent that people didn't understand them. And now they're beginning to be more transparent and people are realizing, wait a minute, not only am I paying a fee, I'm paying a large enough fee that's reducing my return on my investments. And is that right? And is that correct? And is my employer acting in compliance with its fiduciary duty by allowing that to happen? So I think that may be part of it.
Yeah, that makes a lot of sense. And I think that what we can't control, of course, are participants calling into the DOL or whoever it may be and being frustrated about whatever it is, fees or performance or what have you. But what we can control is going back to where you've really been trending this whole way is having policies and procedures set up and understanding exactly what you're doing, setting up a committee that's going to review this, and also, very importantly, knowing who you work with and trusting those providers to take that. And so quickly, before we really delve into the trends, I think it's important to take just 1 minute to follow up on what Bill mentioned earlier, and that is basically what can be delegated to fiduciaries from plan sponsors and what cannot. And so I'm not going to read off each one of these, but most of you probably have 3 different roles being played within your plan, right? And that's going to be your record keeper, who you might deal with the most, your third-party administrator, and then you probably have an advisor too. You may not, but you might have an advisor or somebody who comes in and educates your participants on the investment offerings. And all of those, you can have different levels of fiduciary protection from those companies that can really take on some of that liability for you. But Kathy and Bill, this is where it gets pretty interesting. What cannot be delegated, this part in the gray, payroll, right? Who's hired, who's fired, who's leaving. Of course, you have to keep your providers, your record keeper aware of that, and that's natural. All of you do that. The much broader one is select and monitor plan providers. So while we as a 338 can take on so much liability for you, the plan sponsor, can't get too comfortable with your providers, as I think Bill or Kathy mentioned earlier. Just let it ride for 15 years without questioning or understanding what's going on. And I think that what we're going to see in some of these lawsuits we're going to discuss, and let's go ahead and talk about it a little bit right now, Bill, if you'd like to, is plan sponsors really can't get away from this because so much of it is what these providers have done that has not been in the best interest of the participants. Is that right?
That's right. And it's hard to tell whether I don't think, unless you really have a bad provider, I don't think any provider is trying to do something that's not in the best interest of the participants. There may be providers out there that, and we'll see in one of the cases that we're talking about, there were claims made that in that case, the employer, which was a mutual fund company, was trying to make itself richer. And there may be cases where advisors are trying to get a plan to invest in mutual funds or some other investment that will line that advisor's pocket, but that doesn't happen very much. I think mostly it has to do with the fact that there are so many variables in the market, so many things change, and you have to keep an eye on the investments, the performance of the investments, the cost of the investments. You just have to keep a constant eye on those things. And as you said, Zach, most of the folks that are going to be responsible for administering a company's 401k plan, the CFO, the CEO, the head of the HR department, somebody like that, has lots of other things that they're trying to do and probably doesn't have a lot of experience with 401k plans. And so they need these professional advisors. And most professional advisors do a good job, but you've got to understand it is the employer's plan, and the employer has to understand what's going on with the plan. It has to pay attention to what its advisors are saying, ask questions, meet on a regular basis, review investments, the performance, the fees, review all those things, because fiduciaries have personal liability. And so you have personal liability to monitor the providers to your plan.
Yep. And one thing that we touched on last time that I'm not going to go too much into, and it's the slide, the different types of fiduciary providers. Anybody who was on our last call, we talked about this for the majority of it, but it's worth knowing, and you may already know or you may not, and it's worth knowing the people who serve as your advisor on a plan, those who serve as your investment manager on a plan, your third-party administrator. Do they take on any of these 316, 321, or 338 roles in terms of being a fiduciary provider? And yeah, we just talked about it. You still have a major duty in this to monitor them regardless, but it is worth knowing whether or not somebody does take on some of that liability for you for the role that they play. Kathy or Bill, anything to add to that quickly before we jump into trends?
Just to reiterate, when you're setting up your plan and you're getting your service providers in place, I always think it's a good idea to keep track of who is serving as a fiduciary and which of your service providers are not, so that you are very clear on the roles of everyone that's touching your plan.
That's good advice, and you have to be careful about that, because I have always said that it doesn't make any difference what you say you are. It's what you do that determines whether you're a fiduciary or not. So you can have a provider who says, I'm not a fiduciary, all I do is follow the instructions that you give me, when in fact they are acting with discretion and are acting as a fiduciary. And the problem with that is, as I said, it doesn't make any difference whether they say they're not a fiduciary. If their actions are such that they are a fiduciary, then they are a fiduciary. But if they don't want to admit that, then before you can get to fixing the actual problem, you have to argue with them over whether they're a fiduciary or not. And that takes time and energy and could take money. So as Kathy said, I think it's very important to make sure that you understand and they understand who's a fiduciary and who's not a fiduciary. I think that's very important.
Okay. Good takeaway. And now let's jump into what we're here to talk about, which is trends in retirement plan lawsuits. And really, I think what I've seen, Kathy and Bill, and correct me if you've seen differently, but the majority, if not all, that I've read through leading up to this over the last few years of the claims really center on fees, performance, and investment options, perhaps some combination of those. And I'll start with the fees portion. And you've really got several different areas of this. You've got first your providers, right? Are you paying a fair wage to your providers? Are your providers coming to you with benchmarking to show you, at least annually, here's what you're paying compared to other plans your size across the country? That should certainly be something you're receiving from them. And then outside of that, it's really the investments. You talk about different share classes, which we don't have to go too far into, but you do need to understand, are they giving you an active manager perhaps that has continually underperformed their benchmark, when in turn your participants could have paid significantly less for a passive index fund, if you will? So what are you seeing on the fee side? Is that pretty much, are those the two categories of it? Or Bill, I'll start with you. What have you seen recently?
Yeah, I think that's an issue that I think employers have to be concerned about. The share class situation, which we're going to talk about in a case that we're going to get to in a minute, is one that can come up probably more often with larger plans. But the thing that you have to be aware of with respect to all of this is, when it comes to fees, is that ERISA does not require any employer to choose the cheapest option. It requires you to pay a reasonable fee for the services that are provided. So that actually makes it a little bit more difficult, because you have to figure out what really is a reasonable fee. So things like benchmarking, as you suggested earlier, are a good idea to protect yourself from some argument that your fees are too high. What are other similarly situated plans paying with respect to fees for similar services? And you should expect transparency with respect to fees, what your managers are paying and what the funds are charging, and that sort of thing. And you should ask for that. So those kinds of things can help protect you too.
Yeah, and
Kathy, what did I miss?
I would certainly agree with that. The cheapest option is not always the best option. So understanding what you're getting for the amount of money that you're paying is very important, because fees will vary drastically among service providers, but so will services. So those go hand in hand. You want to pay a reasonable fee for the services that you are actually getting. And even with all of the new rules requiring disclosures to plan sponsors and to plan participants, it is sometimes difficult to understand those. So ask questions and get those providers to help break it down for you so you truly understand what it is that your participants are paying.
I'm glad you said that, Kathy. That's a really good point. So we were, our team was working on a prospective client not too long ago who was just wanted a different look at their plan and maybe a different provider. And we looked through their fee disclosures, and it was about 16, 17 pages. And somewhere in small font between pages 4 and 5, we sort of found all the different fees that we needed to find. Nobody else can do that. It's just you got participants who are working hard every day for the company and don't have time to go comb through these things like we do. But I think you're exactly right. I think that when the providers provide you with those disclosures, perhaps if you don't understand them already, say, sit down with me, talk with me on the phone, show me exactly what these costs are, and help me identify them. I think that's a great point.
Treat me like I'm 6 years old. That's what I like to say. There's nothing wrong with asking questions. In fact, you really have a duty to ask those questions and have them keep telling you until you understand.
Yep.
Nothing wrong with
Agreed.
that.
And this slide, we don't have to go through all of this, but these are just some maybe questions that you might have from those plan sponsors on the call and some answers to those. And how do I know what a manager charges? You can look at a plan level asset statement, or hopefully with your providers, you're having at least annually, some prefer quarterly or semi-annually reviews, which that should be brought to attention. Also, some kind of benchmarking should be part of each one of those, as we talked about earlier. So let me go back one and talk about performance and where I guess firms or companies recently have maybe started to find themselves in a little bit more trouble. I don't think that it's performance itself, right? So if you've got an investment that just has a horrible history and a high cost, clearly then performance is going to factor into that. Kathy, the ones I've read, and you tell me, are really focused on too many options and creating too much confusion and allowing too much leeway maybe for participants who don't really know the investment world to go out and select investments that could be too risky. What are you seeing?
Yes, absolutely. And it's really hard to put a number on how many options is too many, what is the perfect number for your plan, because it varies drastically. And we'll get into another case in a little while that had a lot of options between something like 32 and 46, and under those circumstances that was appropriate for their plan. But in a lot of situations that's too many. If you have so many options and so many investments, it's just going to overwhelm the participants, and they may ultimately just not choose to invest in anything because they can't digest the information to make a decision. So you do really want to understand the participants, their level of comfort with investing, what resources are available to help them choose investments, and pick what is appropriate for your particular circumstances. And that's back to what we've been saying. You need a process, you need expert advice, and you need documentation of the reasons that you made the decision that you did.
Bill, anything to add to that?
Oh, I think that's very important. And I think the trend towards investment education for participants is a good one. And I think the trend toward lifestyle funds, or really target date funds, are even better than lifestyle funds. But target date funds, that's very helpful. Most participants don't know the difference between a stock and a bond, much less how to structure an asset allocation that they need to have. So you give them, in some cases, if you give them 50 mutual funds and say pick your portfolio, you're just asking them to pick what looks like the safest option and put everything in the money market fund, which is going to give them less than 1% or maybe 1% return. You have to take some risk to get the return, and it's hard for employees to understand how much risk they need to take. And so the target date funds have that baked in, and so you choose the target date fund, and then you don't have to worry about it anymore. So those are good. And for those employees who want to know more, offer some investment education for them, so they're not relying on their brother-in-law, which is what a lot of them do.
Yeah, it's a little frightening. And we still see some plans out there that have a default investment option that is their closest thing to a money market fund, and that's a little bit frightening, and certainly could be something that could get you into some trouble. But you do want to have a default investment option. The target date lineup, I believe, is the most popular. It's what we know and utilize. But based on what you're saying, Bill and Kathy, I think you as well. That's a model where anybody who doesn't understand it, very, very briefly, the earlier, I mean, the younger you are and the longer till retirement, the more aggressive you are. And then naturally, as the years go and as you get closer to retirement, your risk is scaled back a little bit. So it just puts them in, anybody who doesn't want to sit down and talk to their advisor or spend a lot of time going through it, it puts them in what is, generally speaking, the best investment approach. The other part of this is on these quarterly, semi-annual, or annual meetings, understand how these different investments are performing against their peers. And if your provider, your advisor, whoever it may be, is coming to you and saying, here's where they are, and this one's been down for a couple years, but we still like them, why, right? That goes back to the process of, okay, that's fine, we trust you, but detail why you're hanging on to this versus going through to what might be a better option. So that's just part of the conversations you have in those meetings.
Yeah, we see, for example, I have seen several times where an advisor will say, the person who was overseeing this mutual fund, the investments in this mutual fund, has retired or has left the company. And so we're going to put this on a watch list because we don't have any experience with the people who are taking his place, and we don't know what kind of performance we're going to be able to expect from them. So they put it on a watch list, keep an eye on it. If the people who took over for that person who retired can't maintain the standard that that person maintained, then it may be a good idea to move to a different fund. But if after a period of time they determine that, yes, the new folks are maintaining the same standard, let's take it off the watch list and keep going.
Zach, I can't hear you.
You're on mute, Zach, I think.
My apologies.
Yeah,
there you go.
Thank you for that. Just wanted to go ahead and throw out another poll question for the audience whenever we can trigger that. And here we go. So let me actually bring that out again. Thank you. In regards to the fees in our plan, I know exactly what we are paying to our providers, and I'm cut off a little bit here. I review the fees, but it's really hard to understand, or I have no idea what we are paying. And then it cuts off a little bit again. But yeah, go ahead and take a second to answer that when you have a moment, and we will look at the results. Bill, what do you think is going to be the winner on this one?
I would like to hope that it's number one, but I have a feeling it's probably number two.
That's my guess.
I hope it's not number three.
Number two. Exactly. Number two is certainly understandable, and that's what it is.
Okay.
Yeah, and that goes back to exactly what Kathy, you mentioned a minute ago. It's sort of crammed in there. You get these bigger packages and different statements, and it really takes trained eyes, I think, to identify those a lot of times. So I want to jump into a case study, and Kathy, I think we'll let you run with this one, but I believe in the last few years, you'll know the year, but this is a case study that involves a suit against Vanderbilt, and I will let you walk us through it.
Okay, this is a lawsuit that began in 2016. It was one of the first of a wave of lawsuits that were filed against universities that sponsored 403B plans. And this was a suit against Vanderbilt and the plan fiduciaries that raised a lot of the issues that we're talking about today. 3 years later, after litigating this case and going through the discovery process for several years, this case settled in 2019 for $14.5 million, which is obviously a very substantial settlement in a case that never ultimately made it to trial. So there were concessions made in this case in addition to the money that was agreed to be deposited into the plan for damages and attorney fees and all of the expenses involved. But like all of these other cases, this case was largely concerned about fees, and the fees that were paid for the administrative services, for the record keeper, the third-party administrator, all of the various service providers, and then also the fees that were charged in the investments themselves. Now, we already talked about a fiduciary is responsible for determining what is reasonable, and a fiduciary should pay a reasonable fee for the services received. Not necessarily the cheapest fee, but a reasonable fee. It's very important that the fiduciary understand what that is, so that the plaintiffs in this case felt as though the fiduciaries had not met their responsibility of monitoring the fees, understanding what the fees were, and paying only a reasonable amount. They also alleged, this is going back to the share classes a little bit, that the fiduciaries breached their duties under ERISA because they kept higher cost investments in the plan. And that this goes back to share class a little bit. There are different share classes of essentially the same investment. So if you go to a brokerage firm just as an individual and you want to invest in a particular mutual fund, you're going to pay a lot more as far as an expense ratio for that mutual fund as a retail investor than you typically would in a retirement plan. And even within the retirement plan world, if you've got a very small plan that doesn't have a lot of assets, you're going to be put into a share class that's probably a little bit more expensive. The least expensive institutional share classes are available to the larger plans. And of course, Vanderbilt in this case, it was a large plan and had access to lower cost mutual funds. So one of the allegations here is that they did not monitor and choose those lower cost funds when appropriate. So as part of the settlement, Vanderbilt agreed to provide information about fees, which ERISA already requires that a plan disclose the fees that are paid to the participants, and also it requires that service providers disclose fees to the plan sponsor. But Vanderbilt agreed to provide that information to try to make it clear, and also to initiate a request for a proposal for services from multiple record keepers, and as part of that, to specifically request that those record keepers break down the fees so that they could understand on a per participant basis what an individual participant in the plan might have to pay for those services. Also, as part of the settle, oh, go ahead.
I was gonna say, so basically they were required to do what they were supposed to do in the first place anyway.
Yeah, yes, yes.
Yeah.
Yeah, I've got to pay a lot of money and I'm going to do what I was supposed to do in the first place. So then as to the investment performance, another claim as to the investments was that the fiduciaries did not appropriately select and monitor the investments, and they kept underperforming funds in the plan when perhaps they should have replaced those funds with something a little bit better. As part of this agreement, Vanderbilt agreed to continue its relationship. It had a service provider that was responsible for monitoring investment, monitoring performance, and if they were to go with another investment provider, they have promised that they will continue those services. They will have a professional, an expert available to them to continuously monitor the investments that are in the plan, so that they can make appropriate decisions to replace an underperforming investment when necessary. And then the other issue they raised, the plaintiffs raised issues about prohibited transactions. And this one is a little bit unusual, and it may be something that we start to see a little bit more. We've seen a lot of focus on fees and investment performance, but in this case, they had an issue because one of the record keepers that they were using was taking the information about all the participants and their account balances and then marketing directly to those participants for additional services. And the plaintiff said, hey, Vanderbilt, you've got a responsibility to protect our personal information. They are engaging in prohibited transactions by trying to profit from our money in this plan. And just briefly, as to prohibited transactions, both ERISA and the Internal Revenue Code have a series of rules that really restrict what service providers and plan fiduciaries can do. And those rules are designed to prohibit some kind of self-dealing. You cannot use the assets in the plan to benefit yourself as a service provider. Or as a fiduciary, and there are lots of ways that those can be breached and prohibited. Now, interestingly, in this case, before we got to the settlement, the judge had dismissed the prohibited transaction claims, but some related claims had continued on about a fiduciary's duty to maintain the confidential information. So, as part of this settlement, in addition to paying the money, agreeing to provide fee disclosures, and agreeing to continue to monitor these investments, Vanderbilt also agreed that it would prohibit its record keeper from using any of the personal information about the participants to market additional services to them. And if they were to change record keepers at any point, they have to enter into a contractual restriction preventing that record keeper from reaching out to participants with additional services unless the participant requests that first from the service provider.
Excellent, thank you. That's a detailed one. I remember reading about that. It's been a little while, and so it's interesting to revisit it and understand where it is now. So thanks for that, Kathy. And what I'd like to do is just do quickly one more poll question with the audience before, Bill, we let you jump into a next case. And this says, and again, my screen's cut off, so I apologize, but it says, in regards to the investments in our plan, we have delegated the investment selection and review, and I'll let that finish. Number 2 is we look at the investments periodically, but we don't have, and I'm cut off. And then 3 is we don't formally review the investments in the plan. Hope it's not number 3, Bill and Kathy.
Yeah, I assume that number 1 is intended to say we have delegated the investment selection and review process to a professional who does it for us, something like
Agreed.
that.
Yeah, probably thinking about a 338 or something along those lines.
Yeah.
And then I'm assuming number 2 says we look at the investments periodically, but we don't have a process, right? Or perhaps even a committee for some of the companies involved. So let's see if we can look at answers in just one second. And there we go. Yes, so most have delegated that. Most have, yeah, that's right. And so the biggest part of that is outstanding. Make sure you know it, you understand it, and make sure they are providing you all the information you need during these reviews that you have with them. So Bill, tell us about Tibble versus Edison.
Okay. Kathy, that was really interesting because I also had heard on the periphery about the Vanderbilt case, but I didn't know the details, and that was a very good explanation of the details. There was a lot going on in that case. There's a lot going on in this Tibble versus Edison case too, but the important part of it is really fairly straightforward and simple. unlike the case that Kathy just described, where I think she said it started in 2016 and they settled in 2019, is that right? Something like
That's
that.
correct.
This one started in 2007 and didn't, and actually, frankly, I'm not sure whether it's even over yet. It went back to the district court in 2017. The district court last decision was in 2017, August of 2017. So the Supreme Court case, the one that I'm going to talk about, is the decision was delivered in May of 2015. But what happened in this case was Edison International is a large company with lots of subsidiaries, but they all have one 401k plan, and all the participants of the different subsidiaries participate in that one 401k plan, and it's been around for a pretty long time. And so the plan committee had invested in some mutual funds several years ago, and the share class description that Kathy provided when she gave her discussion of the Vanderbilt case was the issue here with those mutual funds. The way I like to say it is, it's not very different at all from what Kathy said, but mutual funds basically will give you a volume discount. If you are going to spend more money purchasing their mutual funds, then you might get a class of mutual funds that has a lower fee. And as she said, an individual will get a retail class, and a large retirement plan will be able to pay an institutional fee. But the important thing about that is that is not automatic. They don't automatically move you from one share class to another as your volume of assets in that mutual fund grows. You have to ask for it. And so what happened in the Tibble case was the participants, it finally dawned on them that maybe the fees related to because these mutual funds were retail class mutual funds, and maybe the fees related to these funds should have been substantially lower than they were. Something should have been done about it some time ago. So in defense, Edison said, well, some of these mutual funds were purchased or added to the fund, added to the overall investments more than 6 years ago. And while there are different statutes of limitations that apply to different matters under ERISA, in this case, everybody agreed that the 6-year statute of limitations was the one that applied. So the argument that Edison made was, you're out of court because these mutual funds were purchased more than 6 years ago, or were initially included in the investment lineup more than 6 years ago, and therefore the statute of limitations is run, and we don't have to talk to you about these. And the district court agreed with that. Now, this was in California, and so the participants appealed to the Ninth Circuit, which is in California, and the Ninth Circuit agreed with that. So then it went to the U.S. Supreme Court. And the U.S. Supreme Court said, wait a minute, you as a fiduciary, Edison, have an ongoing duty to monitor your investments. It's a separate and distinct duty from the duty that you have to prudently choose those investments. You have a duty to prudently choose your investments, but then you have an ongoing duty to monitor those investments. It's like they likened it to trust law, where a trustee of a trust has an ongoing duty to monitor the investments in the trust. And so they said the statute of limitations doesn't start to run on the ongoing monitoring until, it's an ongoing sort of statute of limitations. And we see that now. I'm going to go back to the case itself, but I will say that we see now that most employers, especially those that have 401k committees and use advisors, will monitor on a regular basis, quarterly, semi-annually, annually, their investments, and all the things that we were talking about. Are they monitoring they monitor the fees, they monitor the performance, they monitor all of those things on an ongoing basis. And that all goes back to this case, Tibble versus Edison. So the case bounced around some. The Supreme Court remanded it to the district court, and Edison made some more arguments. I'm not going to get in the weeds on those, but they made some more arguments that they shouldn't have to suffer because of not changing the share class. And it went back to the Court of Appeals, and the Court of Appeals wrapped Edison's knuckles again and sent it back to the district court, and the district court determined then that it went back to the district court to determine, now that we don't have to worry about the statute of limitations, was there a breach of their fiduciary duty? And the district court went through an analysis and said, yes, it appears that there was a breach of fiduciary duty by not changing to institutional shares, and left it that the plaintiffs were to provide the district court with their, and I guess the defendants would be involved in this too, with their determination of what the damages should be. And they set the damages either at what the S&P 500 had returned during the period, or what the plan had returned during the period, or what the highest investment in the plan had returned. But it was going to be several $1 million in damages. There will be several $1 million in damages. And under ERISA, the court has the ability to order that the plaintiff's attorney's fees be paid. And in this case, the plaintiff's attorney's fees were $4.5 million.
Ooh.
And yeah, well, I meant at the Supreme Court and back. Like I said, this case has been going on for 10 years. The court originally awarded a fee of less than $500,000, and the Supreme Court said, based on what these plaintiffs have gone through, I think you should revisit the fees. And so the district court was going to revisit the fees, but I didn't see that they've decided how much the fee was going to be. So don't know, but these cases are expensive and they take a long time to come to a conclusion.
Yeah, that's interesting. And obviously not the outcome they were looking for, but the bottom bullet here: have processes, follow up procedures, monitor providers. That's the entire theme of today. And we're up against the clock here, but there was a case that was a victory for those who did just that. Kathy, do you want to just briefly touch on this?
Sure. I know we don't have a lot of time. So American Century is a case that shows how to do things right. And it's all about having processes and procedures in place and documenting your decisions. This case went to trial. The defendants won at trial, and they won because of their processes and procedures. Of the things that the court noted were, the committee that's exercising the fiduciary duties received fiduciary training when they came onto the committee. They received a copy of all the plan documents and the investment policy statement, and they read those documents and they understood them. They met regularly, at least 3 times a year and more if necessary, if they had things they needed to address and talk about. They considered the investments that were in the plan. They talked about the number of investments. This is the plan that had a large number of investments, somewhere between 33 and 46, which is a lot more than we would typically see in a retirement platform. But they had a reason for that. They did it because the employees that were making investment decisions were, they were financial planners, financial advisors, and they had the sophistication to be able to choose, and they wanted the options for their particular plan.
Kathy, we might say they had an investment policy statement too, which allowed
Yes.
them to invest in proprietary funds if they met the other requirements. And that investment policy statement, which we haven't mentioned yet, is an important document that employers should have.
Mm-hmm. Yes, absolutely. Every employer should have an investment policy statement. You should know what it says, and you should follow the guidance in that investment policy statement. Yeah, I know we're short on time, so just briefly on the proprietary funds. Those are funds that are, all sponsored, managed by one particular financial institution. In this case, American Century had American Century funds, and the court went through a lengthy analysis of that and ultimately determined that that was okay. And they looked at the processes and what the committee went through to make the determination that those funds were appropriate in this particular case.
Yeah, when you look at the facts of this, you would think that because American Century was using its own funds, the plaintiffs argued that American Century was doing that to line its own pockets. But as Kathy said, the court determined that that was not the purpose, and the committee was very careful about how it determined and watched the investments and how it determined what investments to use. I was actually a little bit surprised because of the proprietary funds, but the court was very detailed in its analysis of what the committee did and how it did do all the right things.
Document, right? So it basically comes down to
do
it and document. Yeah, that's right.
Have a process and document what you do.
That's right. So we have a handful of questions that I think for the sake of time, what I'll do is Kathy and Bill get with you and just be sure that we answer those individually. Some of them are a little bit more pertinent to the company themselves. So we will get to that. I do want to mention that we have another webinar coming up on Thursday, November 19th, where we're going to talk about IRS audit issues. So have that on the calendar. And then if I can get back here, I'd like to just pull the two of you up once again, two people who can help tremendously in terms of preparing or fixing or whatever it might be. But Kathy and Bill, you were wonderful to be on here with us today. Emails are listed right here on this page, so I'm just going to leave it there. There is an exit poll as you close this out or as we end this session here in just a minute. But Kathy, Bill, thank you so much. It's been a pleasure to work with you leading up to this and certainly to perform this with you today.
Thanks for having us.
Yeah, I enjoyed it. You're very welcome.
Good. All right. Thank you all, and hopefully we'll see many of you soon.